So before we begin, I just wanted to pass it over to Sandy, who is the Pro Bono and Public Services Coordinator for the Dauphin County Bar Association.
Great, thank you, Ashley. On behalf of the Dauphin County Bar Association, we are very pleased to partner with MidPenn Legal Services and the Dauphin County Library System to present the Lawyers in Libraries series of monthly programs. We look forward to your questions in the chat and your comments tonight. And please let us know if you have suggestions for future topics for our monthly Lawyers in Libraries, as we're working together to help everyone in our community. And I am delighted to have with us tonight to talk about the question presented is, want to avoid an eviction? Try mediation. And our presenters are Matt Rich of MidPenn Legal Services and Attorney Jordan Cunningham of Cunningham, Chernicoff, and Warshawsky. And both Matt and Jordan are members of the Dauphin County Bar Association, and we are pleased to have them. So I think I'm turning it over to Matt now.
Thank you, Sandy. So yes, as Sandy had mentioned, Matt Rich, I'm an attorney with MidPenn Legal Services in the Harrisburg office. I practice primarily in the area of landlord-tenant. We represent tenants or the light side, as we like to say, and Jordan, who I'll have introduced himself in a second, represents landlords, aka the dark side in many cases. I kid, but so we're hoping to offer essentially like a point counterpoint or both sides presentation here this evening. We're going to talk about a couple of different things. We'll first touch basically on some eviction basics, walking through the general process so that you all understand how a case gets from there being an issue to then leading into court, and then what happens from the beginning to the end of the eviction process. We'll then talk about different moratoriums that are in place at present, both with the CDC order and with the Harrisburg City moratorium. We'll go into those in a little bit of detail. We don't want to take too much time on those. Those could be a whole presentation in themselves. We just want to note them so that folks are aware that they're in existence at present. And then lastly, we'll touch on our mediation services. So Jordan, I'll let you introduce yourself first before we get going.
My name is Jordan Cunningham. I've been practicing in Harrisburg for about 45 years. A substantial amount of my practice is related to subsidized housing and representing owners of subsidized housing throughout the Commonwealth of Pennsylvania. And I also do a fair bit of litigation. And it may surprise people that between Matt and myself, we generally can work most things out, be dark side, light side. But at the end, all that, I will say this up front, all that a landlord really seeks is to provide housing and a return on his investment. And from Matt's side of it, all that he, I think, really wants is that his clients have a fair, clean, orderly, and secure place to live and have an ability to pay the rent. And that's what led to this whole situation about 9 months ago. After looking at COVID, how are we going to get from the stark reality of individuals who can't pay their rent for one reason or another? On a landlord side, your only way to approach the matter is to either evict or take continual losses over a period of time. And that really doesn't aid the problem. So not that we can address the entire issue, but tonight we're going to examine maybe another way outside of the box to approach the situation between a landlord and a tenant. So with that, I'll turn it back over to Matt.
Great, thanks, Jordan. So as Sandy mentioned earlier, we're going to focus mostly on the mediation program that we've begun here in the recent past. But before we get to talking about the mediation program, we want to talk about the process that leads us to that. So there's our information, so that you are aware and have that. I don't want to necessarily speak for Jordan, but I know that, you know, we're presenting these, everything that we're presenting here just for general educational purposes. I will put the disclaimer that this is not meant to necessarily be legal advice for anyone in particular, mostly just for general educational purposes. I know that if there are any questions throughout here, please, those who are on the call, although Kay Pickering's with us, and I know Kay's probably heard this kind of same presentation in one form or another many times over, but feel free at any point in time to chime in here and have some questions so that Sandy can perhaps interrupt us at some point, or you know, if we are breezing through this, maybe we'll touch them on at the end. And then if there are any follow-up questions, I know that Ashley and or Sandy could get a hold of us if the need arises to try to answer any questions that arise out of what we covered here this evening. So first, I'll lead off this first one here and start by talking about just eviction basics. So at the beginning of a dispute between a landlord and a tenant, generally speaking, there is a notice required, an eviction notice or a notice to quit, that a landlord must provide to a tenant in the event that the tenant has defaulted the lease in some form or fashion. So you'll see we note here that the notice is required by law to be a 10-day notice if the issue is non-payment of rent. It's a 15-day notice for another breach of a lease or an end of the lease term. Once that notice has been provided, that notice is meant to, you know, again, put the tenant on notice, obviously, that, hey, you violated your lease in some fashion, and you either have to pay rent if you owe rent, or you have to cure whatever the breach is if it can be cured, or vacate the property, or I, as the landlord, am going to take you to court. And so if the notice is provided and the tenant and the landlord aren't able to resolve the issues, the next step, if the tenant remains in the property, is for the landlord to file a complaint at the local magisterial district judge's office. So we here in Dauphin County have 13 different magisterial district judges throughout the county. And so from a landlord's perspective, based on wherever the property is located, they locate whichever magisterial district judge and whichever magisterial district court that they are in, is in their locale, and they file a complaint with the judge's office. The judge then schedules a hearing no sooner than 7 days from the date that the complaint is filed, but no more than 15 days from the date that the complaint is filed. We have a summary eviction proceeding here in Pennsylvania. The way that the process is set up, it moves relatively quickly. There's not a whole lot of time. And as you'll see when we get talking here, from beginning to end, even if a notice is provided, you're probably talking about anywhere in the neighborhood of maybe 30 to 40, maybe 50 days from the time a notice is provided to a case is filed until an actual eviction occurs. I know I've talked with tenants over the years that come from different states, and I've heard them, you know, on certain occasions say, you know, oh, you know, the landlord's going to have to give me 6 months or a year, and that is certainly not how the process works here in Pennsylvania. We have a much quicker process from beginning to end. Now, the tenant also has a right to appeal any judgment that is entered against them to the Court of Common Pleas. That is the next step on the legal hierarchy of these cases. So these eviction cases start in magisterial district court. If the hearing's held and the judgment's entered, the tenant then has the right to file an appeal. In the case of a judgment for possession where the eviction's at issue, the tenant has 10 days from the date of the judgment to appeal the possession and stop the eviction, or the tenant has 30 days from the date of the judgment to appeal just simply the monetary portion of the judgment if they don't agree with the amount of money that the judge says that they owe. However, that type of appeal does not stop the eviction. So if a person has a judgment entered against them and they're trying to prevent an eviction, they have to appeal that judgment within 10 days from the date that the judgment is entered. Now, Jordan, I will pass this over to you then to talk about the tail end of the eviction process that you're probably more familiar with, having worked with landlords.
Assuming no appeal has taken place from the magisterial district judge's decision, A landlord has the right on the 11th day after the date of the judgment, not the date that somebody receives it in the mail, not 10 days or 11 days after you may have heard the verdict on the street. It's 11 days from the date that appears on the judgment that is issued by the judge. So if the judge issues a decision, say on a Monday, and a week later you receive that notice, the 10-day period to take the appeal has effectively been reduced to 3 days, because you must file that appeal within 10 days of the date of the judgment. And the landlord cannot seek what is called a request for an order of possession until the 11th day. When the 11th day arrives, the landlord may go to the magistrate's office, request that the magistrate issue an order of possession pursuant to the request. The magistrate then, most have constables attached to their office, will have their constable, in essence, find the tenant's home, post the home, and give the tenant the time in which to remove themselves from the premises. So when the MDJ often says that a tenant has 21 days to be out, that's 11 days plus the 10 days given by the constable to remove. And most of the requests and orders for possession of documents fill out by the state constable will say you must remove yourself and all possessions by a date certain at a time. And that's basically the system as it works. Now, once notice of appeal has been filed, the landlord has no further right at that point to seek the order of possession and the request for possession because effectively the case has been taken out of the magistrate's hands, or the magisterial district judge's hands. So at that juncture, there are a number of other factors that come into play at the common pleas level. And Matt's going to cover that later in the presentation. But up to the 10th day, you have to the 10th day to file that notice of appeal. On the 11th day, the landlord has the right to request the possession. And generally, the constables will give 10 days for the family to remove themselves from the service of the request for possession. So that's basic process at that point. If the judgment is solely for non-payment of rent, the eviction can end upon paying the amount of the judgment plus the cost of the constable. Now, a lot of people confuse this. Let's say your judgment was entered the 24th day of the month. We'll use January as an example. And no appeal is taken. And on the 11th day, which would be on or about February 5th, the landlord seeks the request for possession. And the constable comes out, posts the eviction or serves the eviction notice on this request for order of possession. The tenant only has to pay to stop evictions just for non-payment of rent. The amount the judgment entered by the magisterial district judge plus the constable's costs. February rent does not have to be paid because that's not part of the judgment. For other reasons, for not is separate and apart from non-payment of rent, that doesn't apply. If the eviction was, say, for housekeeping, or the eviction was for criminal acts within the premises itself, together with non-payment of rent, simply paying the rent doesn't end the eviction in those types of situations. Matt, back to you.
Right. Yes. And so, we go over these basics here just to keep those in mind for later when we come back to talking about the mediation program. what we'll end up touching on at that point, like where the mediation program fits within the context of this process. So just keep this process in mind for later, and we'll certainly be coming back to that and talking about that. So the next thing I want to move into, and again, we could spend an awful lot of time talking about these things, but we just want to hit on these to highlight them, is to touch on these two different eviction moratoriums that are in place at present. Now, the one thing I'll say about this, right? So in the context of those first two slides, the information that we provided is pretty well set in stone, and very rarely are there any changes made to the process that we outlined in those first two slides. What I will say about the next several slides when we're talking about these COVID-19 updates and these different moratoriums is that the only thing that has been constant since COVID hit, especially with regard to the legal system and its handling of different moratoriums, the only thing constant has been change. And we had a point there, especially early on, where, I mean, literally things were changing seemingly by the day, maybe even by the hour sometimes. And Jordan and I would have a conversation about something, and everything was true on, you know, a Monday afternoon. And by the time we spoke again on Friday, things had changed drastically, and we had to have a whole new conversation. So I will say that this is, as things stand right now, today, there are literally going to be some changes to what we're going to talk about here, maybe even tonight or tomorrow. There may very well be some other drastic changes here in the coming months. This is just what we know is in play as of today. The other thing that I will say about this is that the only thing that has been certain about how our court system implements these orders and these moratoriums has been uncertainty. We have found, and I think, Jordan, I think you agree with me on this, that what we have found over the course of the last almost year now, we're getting there, 10 months or so, is that ever since COVID hit, and ever since these different moratoriums have been thrown in place, whether it be by the Supreme Court, whether it be by the governor, whether it be by the legislature or the Center for Disease Control here that we'll talk about, the problem is that we get these overarching mandates by the folks who are issuing the moratoriums, and then you have the whole trickle-down effect on the court system, where the court system has to figure out, number one, what exactly these different moratoriums mean, because they can get very complicated as far as all the different aspects of them, and what they apply to, what they don't apply to, what it covers, what's an exception, those sorts of things. So not only do they have to figure out what exactly the orders mean, they also then have to figure out how they're going to implement them. And so, what we've seen on many occasions is we'll see, if the court system starts at the top of the Supreme Court, works its way down to the Superior Court and the Commonwealth Court. Then you have each county, each one of the 67 counties has its county court of common pleas. And then below that, you have the magisterial district judges. And again, here in Dauphin County, 13 different magisterial district judges' offices throughout the county. And so what we have seen is that oftentimes we'll have an understanding of how something is supposed to work on the state level, but then maybe by the time we get to the court of common pleas, the county court, they might be implementing it a little differently than what we were expecting from what we read or heard from the state level. And then
it's true from county to county too, Matt.
From county to county. And then when we get to the magisterial district court level, I know I've heard on a number of occasions that the magisterial district courts seemingly are not provided an awful lot in the way of direction from whether it's the Court of Common Pleas or the Administrative Office of Pennsylvania Courts on a lot of these things. And so in many cases, the magisterial district judges are left to figure these things out kind of of their own, or on their own or of their own devices. And what that can lead to sometimes is that, I mean, literally you could be in one court and a judge is doing something one way, and then you go to the neighboring district court and you find that judge might be doing something a little different. So we say all these things, and what we're going to cover here is meant to be kind of the general overarching way that this is supposed to be working, but just understand that like the most important thing that we've been at least I've been trying to tell clients and social agency workers that I've been working with is that it really is incumbent upon an individual to figure out exactly like what court are you in, which judge is it, and to try to figure out exactly what it is that that particular judge is doing, because it could change from one to the next. So Jordan, if it's all right, I'll let you take away the CDC order if you want to talk about that, and then I'll come back in to talk about the city moratorium, if that's all right.
That's fine. Back in September, the governor's order had, with regard to moratoriums, had ended. There was a question as to whether evictions were going to begin again, and in fact, there was some start in some courts of eviction activity. And effective September 1, the CDC entered an order setting a moratorium in those actions where the only basis for the eviction was non-payment of rent or what's known as end of the term of the lease. The idea was that you did not want to place families, basically families and individuals in a situation where they were rendered quote unquote potentially homeless and then spread the disease by other methods and means. So through December 31, the CDC order of September 1 was in place. There was a question as to whether that order, in effect, would be extended. And before the end of the Trump administration, there was an extension of that particular order. However, upon the inauguration of President Biden, there was an executive order that we have heard had been issued, which would extend that CDC order or something similar to it through March 31. But nobody knew what the exact details of that CDC order would be, or whether in fact it would come from the CDC, but we all assume it may. And as of tonight sitting here, Matt had referred to some things potentially changing, and we're waiting to see the announcement and presentation of what the new CDC moratorium will be. It's supposed to be released tonight. I don't think that we've seen it yet tonight. We have expectations that the wording, since everybody seems to be reached a point of being comfortable with what the moratorium means, not that you agree with it, not that you believe it's the best method for addressing the issue, but we all assume it's still going to refer to individuals who are being evicted for merely non-payment of rent, or in the alternative, end of the term of the lease. So it is, as the slide suggests, that we expect that will extend through March 31. The governor has no order out at this point. He feels that he doesn't have the jurisdiction to further extend any moratorium orders. He made that clear back in July. And so we are now waiting for the CDC. In between, and Matt's going to talk about it, the mayor of Harrisburg also entered his moratorium proclamation, I believe it was.
Yep.
And so at that point, Matt, you can discuss the intricacies of that.
Yeah, and again, I want to try and breeze through these as much as we can, because I don't want to get bogged down too much in this, but just a couple of things to know, especially for tenants, tenants advocates, anybody working out in the community. This order does not automatically apply to all tenants, whereas many of the other moratoriums in play did, like the governor's moratorium, the Supreme Court moratorium, they applied to everyone without anybody having to do anything affirmatively. But in this case, a tenant has to actually sign what's called a declaration, a form that's provided by the CDC, and then the Administrative Office of Pennsylvania Courts, the AOPC, also has a form which I have links to later. And then the tenant has to provide that form to his or her landlord in order to seek protections of the order. So if you have a tenant who has not provided the declaration, this does not apply to them. The other thing I'll say is that the order only necessarily applies to cases where the only issue is non-payment of rent. For tenants advocates, there's an argument that it should also apply to the end of a lease term case, a lease termination case, but that's arguable. And I will say that generally speaking, the court system takes the position that it only necessarily applies to cases where the only issue is non-payment of rent. So again, if you have cases where the tenant is doing damage to the property, or there's some sort of public health or safety hazard, or the tenant has breached the lease in some other fashion, criminal activity, unauthorized occupants, etc. Those are all situations to which this order does not apply. It's only a case where non-payment of rent is the only issue. That's a common misconception that folks say, oh, I know there's this CDC order and that means I can't be evicted. And that's a big but there, but it's only if your only issue is non-payment of rent. The other thing I'll say about this is the order does not mean that judges are not accepting the filing of new cases. In many counties in Pennsylvania, especially here in Dauphin County, we got out ahead of this early on, very early on. Our president judge issued an administrative order as soon as the CDC order came out that said that the processes were to continue all the way up and until the final step. So cases are still being filed, hearings are still being held, judgments are still being entered, and in some cases, orders for possession that we talked about earlier are still being issued, but the CDC order comes in at that final stage in the process and prevents only that final step, which is the actual physical eviction, from taking place. So that's another thing to keep in mind. I mean, so I've heard from some tenants calling me up and saying, hey, I gave this declaration and I don't know why my landlord was still allowed to proceed. I thought that would stop everything. And that's unfortunately not the case. It doesn't necessarily put a freeze on anything except for the last step. This is what the declaration contains. I think of this as a checklist. I'm not going to go over all the details. They're all here. I'm going to provide links to forms that you can review them on the declaration forms. Basically, this is the one thing I will say about the declaration form, though, is I know that, these declarations are readily available. Like I said, the links that I'll provide, you can go and pull them up, and you can print them out, you can sign them, and you can hand them over to your landlord. And I understand there are many tenants who are in very desperate and dire need at the moment. And so, in those cases, desperation, sometimes breeds some things that, forces folks to do some things maybe they shouldn't. One thing that I just want to make very clear is it's very important to read everything in here. This is a declaration. And again, that's why I say I think of it as a checklist. You have to be able as a tenant to read over all of this carefully and check off every box. If there's anything on here that doesn't apply to you as a tenant, or if you're a tenant's, advocate and you're working with a tenant, if there's anything on here that doesn't apply to the tenant, then the tenant absolutely should not sign this in the declaration, and the order will not protect them. They want to be very careful that they're making sure that it does actually apply to them. And I say that in particular because any false or misleading statements may result in potential criminal and civil actions for fines, penalties, damages, or imprisonment, perhaps. I think it would probably take a pretty extreme case. So it's pretty serious stuff. It's not, perhaps just a slap on the hand potentially. So you want to be very careful, make sure that those apply and that you're not lying or falsifying any information. The other thing,
may I jump in just for a second? Along those lines, I can tell you there are certain landlords who will sue serially every month rent is due. And what this has opened up to landlords council is that when the tenant produces the declaration, some magisterial district judges have allowed the landlord's attorneys to ask the tenant, well, what programs did you apply to for rent? Do you have that evidence in the courtroom today? What payments in good faith have you made to the landlord, and why haven't you made those payments? When did you contact the landlord to talk about payment of rent? So when Matt mentions that those issues, you may just check the box and sign it. be very careful, because in that situation where the claim was non-payment rent was one claim in the first action. The second action was end of the term of the lease plus non-payment. The magistrate entered an order of possession based upon tenant's bad faith execution of a declaration. So it can come back to haunt you.
Yes,
And,
be careful, be careful. So that's what I said, I make sure to go over it very carefully with any tenant that I'm working with, that I'm going to have sign it, just to make doubly certain that everything on there is true and correct. Last thing I wanted to hit on, I include this language in here, which is also in the declaration form, which basically an understanding that you're still required as a tenant, even though it's the order and the moratorium prevents the eviction from happening, the actual physical eviction. It does not cancel rent. We probably, you may have seen or heard, there are some movements in some major cities throughout the United States trying to seek the cancellation of rent. There's been no indication thus far in any one of the moratoriums that we've encountered that there is going to be a rent cancellation aspect to any of these moratoriums. Essentially, this is kicking the can down the road, right? Which again, if the need is there, and that's all that you have, and you don't have anywhere else to go, and keeping in mind that the whole purpose of this is to try to stop the spread of COVID-19. If that's the case, then you utilize it if you must, but just understand that it's not a get out of jail free card. It isn't a rent free type of scenario. The rent is still owed, as Jordan said. You may very well, if this thing drags out another 6 months and you give the declaration, you may have your landlord running in there month after month after month to continue to keep racking up different judgments and costs and things in the interim, just to clear their books for whenever the day comes that you ultimately will leave. So that is something to keep in mind as well. And I do have the links there. There's the CDC's declaration can be found there. The AOPC has a declaration form that can be found at that link. The declaration form is more of a template. It doesn't have to be that exact form. So there, it just basically says substantially the same form. You definitely need to have some of those key aspects on there, the checklist and whatnot. But there are certain things that you'll see differ from even the CDC's form to the AOPC's form. So you just have, you can use them as a template and work from there if need be. So now, moving away from the CDC declaration, I'll touch really quickly on just this one slide. The city of Harrisburg actually enacted its own eviction moratorium, right? So the CDC order was a blanket order that was meant to provide at least a baseline protection for tenants across the country. The order did make it very clear that if any state or locality, municipality, city, if any of those wanted to enact their own ordinance, their own moratorium, that they certainly could. It was just the CDC was providing a baseline. And so then on December 17th, the city council had passed a bill that Mayor Papenfuse signed into law as Chapter 3-355 of the City of Harrisburg's Public Safety Code. We're going to call it the eviction. They call it the Eviction Moratorium Ordinance. I'll call it the EMO. The EMO in many ways mirrors the language of the CDC order, in that it only necessarily applies to cases where the only issue is non-payment of rent. I have seen an indication that it also does cover end of term cases. I've not been able to find that language anywhere, but that may be an issue as well. There are a couple of exceptions or additions that the city's EMO adds to the CDC order. The first thing is that the EMO applies to rooming and boarding houses, whereas the CDC order does not. For any of those of you who are familiar with working out in the community with landlords and tenants, you may be aware that we do have a fair number of rooming houses, boarding houses in the city. And I think that the city was cognizant of that between both the city council and the mayor when they enacted this. And I think that they explicitly placed those provisions in there to cover those rooming house, boarding house type of scenarios. City officials, so for instance, the police department and Bureau of Codes are empowered to enforce the order against property owner violators. So, if there is a property owner who's attempting to evict someone in violation of the order, a tenant would call the police, would call the codes department. I didn't note it on here, but 311 is another resource to contact. and those agencies, any one of those agencies may respond to an inquiry related to a violation of the order. And then property owner violators can potentially face punishment, including hefty fines and then potentially even imprisonment. So this was meant to give a good bit of teeth to this, to really try to work as a prohibition against landlords evicting tenants in the city. And again, keeping in mind that this is all based on a public health and safety purpose. We have shelters which are either overrun or because of spacing requirements and social distancing requirements, they're not operating at full capacity. We have our healthcare system dealing with COVID. And so the notion is to try to essentially freeze everybody in place if we can, try to avoid the doubling up and the utilization of homeless shelters to try to prevent the spread. The EMO originally, when it was signed, lasted for 30 days. It's since been extended by Mayor Pappenfus. He had signed a declaration on January 16th. So as we're here talking now, it's currently set to expire on February 15th, but there is a continuing resolution that can be extended for 30 days at a time thereafter. And the word that I had heard through the grapevine is that the mayor and the city council had said that they have every intention of extending the city moratorium throughout the winter. Now, I don't know exactly what that means or as far as a timeline, but throughout the winter. So we may very well see another extension. Keep in mind that this only applies to the city limits. This does not apply to all of Dauphin County, just the Harrisburg city limits. So now I want to move on to talking about the mediation program. Okay, and this is, we've done all that to lead up to where we are now. And this is the kind of meat and potatoes we wanted to try to hit on. So the Dauphin County Eviction Mediation Program is still in kind of the infant stages. We are taking kind of baby steps and working our way towards getting this up and running and really getting it, going full blast. This was created by way of a joint venture between the Dauphin County Bar Association and our office. I don't want to take anything away from the Bar Association and MidPenn Legal Services, but frankly, a lot of it came from Sandy and I working with one another. And a lot of this is born out of just Sandy and I talking about these things, and Sandy really taking the lead and doing a great job of spearheading this program. The program's received and continues to receive input and support from the following. So I just note them quickly: the Housing Alliance of Pennsylvania. A lot of this started from a grant that we were graciously provided by the Housing Alliance of Pennsylvania. We have pro bono or free of charge mediators through the Dauphin County Bar Association that Sandy does a great job coordinating and facilitating. We have landlords involved in our discussions and working on our program. Landlords Council and representatives such as Jordan has been integral in the discussions from day one. Tenants Council and representatives, which for the most part is me, although we do have some local social agencies involved as well. The Dauphin County court system, we've been working with the magisterial district courts, our Dauphin County Court Administration, the Court of Common Pleas, and then even the court itself, and our president, Judge Cherry. We've also pulled in, as we've been working through this, and we pulled into our discussions to try to make the program kind of as robust as far as the services that we can provide, to try to throw whatever we can at helping landlords and tenants solve problems. We've also have community agencies involved. Christian Churches United and Help Ministries has been integral from the start. We have the Fair Housing Council. Salvation Army has come in recently as well, with the Tri-County Community Action Commission and the Capital Area Coalition on Homelessness. And there are some others I'm sure I'm missing, but I mention all of this just to say that we've received pretty resounding support so far. One thing I will say, Jordan, which I don't know if you can maybe kind of hit on really briefly here, is just I was kind of surprised early on when we were talking with landlords, and then landlords council such as yourself, to recognize and find that landlords were so supportive. And so can you maybe give us a couple of quick clips as to a landlord's position and why mediation might be beneficial from a landlord's perspective?
Well, from a landlord's perspective, what you and I have always found out, quite surprisingly, is that there's very little communication going on between landlords and tenants at times. They don't talk, they don't communicate, they don't express concerns one to the other. And I don't know why that is. Maybe it's societal in nature. But in essence, if you think about it, a landlord is very dependent on his, her, or its tenants, because that is the vehicle which drives the monthly rent the landlord uses to pay the debt service, they have debt service, or the taxes, or the utility, if they're paying the utilities, on a month-to-month basis. And most landlords, now there are exceptions, but most landlords that I've been involved with generally want to provide a service and to the tenant. And in providing that service, they need the monthly rent to be paid. Maintenance isn't performed for nothing. Replacement of water closets, sinks, you name it, all takes money of one sort or another. So the idea of mediation is just that. It's placing together two, they're not advocates, but two individuals, if you will, that need to talk about what they can and cannot do and be honest about it, and have an honest broker there to maybe facilitate the conversation. None of it, you couldn't sell a landlord on it being mandatory, because there are certain landlords who simply don't want or don't believe in the mediation system. They want to get to a judgment, take their judgment, and move on. But the vast majority of what I would call either institutional or privately owned, quote unquote, mom and pop or family owned, do have concern about their tenants on a day-to-day basis. So the idea of going to a mediation would save, in essence, some landlords time and money by receiving through mediation, if not a full payment of rent, a partial payment of rent, with an understanding at the end of the COVID situation that there would be along the way an idea of paying all the rent that may be due and owing. And instead of being advocates, they move along on a protracted basis to make a payment. And at least that puts money into the coffers of a landlord in order to pay the debt service, in order to provide the maintenance for the premises. So otherwise, what you have is a situation where either a landlord's driving costs with an attorney, who then tenant, the only avenue of relief they have is to file an appeal, which then requires the landlord to engage and involve more costs as far as a lawyer. And some of the leases provide that all that cost is to be borne, in essence, by the losing party, who, if it's the tenant, the cost of the attorneys is going to be placed upon the tenant, assuming that the landlord can prove their case. All that, theoretically, over the past years has always been a problem for not the institutional landlord, but more or less the smaller, which is the vast majority of landlords, the smaller individuals, because the cost of going to a hearing, the cost of preparing for it, the cost and logistics of putting people together, it's just a time and material project, and it's expensive. So part of it.
Yeah, George, sorry. And also, I think, there's in many cases not much of a pot of gold at the end of the rainbow, so to speak, right?
Right.
These costs, and then, especially if you are renting to tenants who are on the lower end of the rental spectrum, as you can assume, if they're, having financial troubles and aren't able to pay their rent and they're evicted, the likelihood of ever actually seeing that money is slim to none.
Yeah, so the idea was to avoid that. How could we avoid that cost up front? And that's how we got to the mediation program.
And so, and I am trying to be, I always lose sight of time. So I know we have about 10 minutes left I want to try to be mindful of that. But you were prescient there, Jordan. You did hit on many of the things that we're going to cover already. So I did want to just hit on very quickly to make everyone aware that the program that we're offering is for Dauphin County landlords and tenants, and it is free of charge to participants. So there's no charge associated with any of the services that are offered through the program. These are many of the things that Jordan was hitting on. So I thank that, Jordan, because you were right on it. Mediation, again, proactive alternative to this traditional, oftentimes expensive eviction process. It's aimed at trying to keep everyone secure and made whole, or at least as whole as possible, right? I know Sandy, when we're doing some of our sessions, tries to make it a point that, in a really good mediation where it's not like a desperation type of scenario, but in a really good mediation, the end result of a good mediated agreement is likely that both parties will walk away with a little bit of pain, but it won't, even though there is a little bit of pain, it's not as grave a pain as you would have if you hadn't gone to the table at all. And so, the idea is to try to get everybody back to, kind of back to even, back to when times were good, so to speak. And again, along those same lines, it can help avoid unnecessary expenditures like the court costs that Jordan mentioned and attorney's fees. One thing that I really appreciate probably the most about mediation is that it offers the potential to be creative with solutions, right? I mean, that's, I know if, I don't know that we won't show the form here necessarily, but like we have with the mediators, they come into the mediation session with an agreement. And then they use that agreement, then the agreement form to track the terms, and the agreement form is literally blank, right? I mean, you walk in with a blank slate, you talk with the tenant, you talk with the landlord, you try to work out whatever terms are agreeable to the parties, and it just can go in any one of a million different ways to lead to whatever path you have to take to get to a solution, and obviously can hopefully lead to more positive outcomes. Mediation is meant to respect both the tenants and the landlord's rights. So understand that like the mediation program is not there, as Jordan mentioned earlier, like we're not here to advocate for the landlord or the tenant. This is meant to be the middle ground third party to come in and try to help both parties and try to help them reach an agreement to resolve the dispute. Where the program is looking to identify landlords and tenants who are willing to participate as early in the dispute process as possible. So for instance, ideally, we would do that prior to a case being filed at the magisterial district judge's office. Now, for various reasons, which we won't get into now, one thing I can say is it's highly unlikely that this program will ever be made mandatory. And if it is made mandatory, I don't know that it will be made mandatory prior to a complaint being filed. I think in any event, the soonest that we're going to be able to get in, which I'll touch on in a second, is once a case is filed. But we're certainly able and willing to take anybody who's willing to participate, and we would love to have landlords and tenants come to us before a complaint's even filed, because a complaint being filed, number one, costs the landlord money to file it, which are filing fees they then have to try to recoup, and just makes the solution a little bit more difficult if you're trying to get caught up on rent, and you got to get caught up on court costs in addition to the rent. The other thing is, from a tenant's perspective, it creates a record in what's called the Unified Judicial System. It's a computer system that logs any and all filings at magisterial district judges' offices. So the minute that a landlord files a complaint, that's now on the tenant's record. And unfortunately, with kind of the the increasing popularity of technology and folks being able to hop on to UJS more and more readily now, it really does follow around a tenant, much in the same way a criminal record might follow around someone who has a criminal record. So we try to catch it early if we can catch it early. That's why we're trying to reach out to the local social agencies and the folks, the agencies and the workers who are actually out there, pounding pavement out in the street, to see if there's any way we can try to capture landlords and tenants prior to a complaint being filed if at all possible. Now, as I said, their participation strictly voluntary, and I know that Sandy will probably enjoy that I say this. It takes two to tango, okay? Both the landlord and the tenant must agree to participate and register for the mediation session. So if we have a tenant who's really interested in trying to participate, but they can't get a hold of their landlord, and we can't try to get a hold of their landlord, we're not going to be able to make a mediation session work, and vice versa. If you have a landlord who's willing to participate, but the tenant has, ducked their head in the sand and just refuses to cooperate in any way, shape, or form, mediation is unfortunately just not going to work. We need both parties. You'll see there's a registration form later that I'll hit on, and that we need both parties to come to the table at the same time. And right now, the program's working with Magisterial District Judge Barbara Pianca out of her office to accept referrals from cases filed there. That's kind of like a pilot project so that we can work out the kinks in the system, get our process up to speed. And then the idea is, in the big picture, we roll it out to all 13 judges' offices if we get to that point here sometime in the future, where we can handle that type of capacity. But again, as we said, willing to accommodate, try our best to accommodate anyone willing to contact us and seek assistance to participate in the mediation session, even if it's not at Judge Bianca's office. So clinics are currently being held every Tuesday morning at 9 a.m. via Zoom, which is preferable, or for anyone who's used Zoom, you can call in by phone through Zoom and participate, even if it's just merely by phone. Now, obviously, we'd like to have Zoom. I do think that there is something to be said about being able to see one another, but if Zoom doesn't work, if the technology is not available, a simple phone call can work. Translation services may be available if needed. Again, we're in infant stages, so we don't necessarily have everything up and running that we'd like, so that is a tough call depending on the situation, but there's at least a possibility we could try to make translation services available. Each clinic begins with a brief informational session. Everybody gets logged in, everybody's there in one big room. Sandy starts by giving a brief talk, I give a brief talk, and we're mostly describing the process and what services might be available and help the resolution. And then we also have free educational and social services available, aimed at increasing the tenant's stability. This includes financial literacy and budgeting, which is a new aspect that we added recently, and we're really excited about, or rental assistance. That's where the help office that I mentioned earlier, and they played a huge role in what we've been doing. They're on there to talk about what rental assistance options might be available and how tenants and landlords, depending on the circumstance, might be able to go about applying for those. So after the introductory session is complete, landlord and tenant are then transferred into their breakout room with a trained mediator and perhaps others, staff members, the help office, the budget counselors. And in that breakout room, the parties and mediator discuss the situation, attempt to reach an agreement. And again, keeping in mind, the mediator's not there to represent either party, and if we get any of these agencies that get moved from, room to room, we're there to just try to help both the landlord and the tenant, not necessarily there to represent either party. In certain cases, again, the tenant might then be able to even break out into even another separate room if they need to talk with the help office representative confidentially, or if they need to talk with the budget counselor confidentially, to try to help, see what their financial situation looks like and how that might affect their ability to reach any agreement in the mediation session. At the end, if there's an agreement, the terms are tracked throughout the process, and then ultimately the mediator writes up the agreement, all the terms, so that all know exactly what's expected of them. Both of the parties are provided the agreement for them to sign, and then ultimately all involved are provided a copy of the agreement. If both parties agree, if the situation can't be resolved in one sitting because it might take more time to do a budget counseling or apply for rental assistance or what have you, mediation sessions can be continued. There can be multiple sessions if needed to get a situation resolved. They can be held on days that are other than the Tuesday clinics. I think by and large we're trying to start on Tuesdays, but if we have landlord and tenant show up and say, hey, the only days we can do are Fridays, we can try to work with that based on the availability of mediators. It's meant to be flexible. We're trying to do everything and anything that we can. Sandy has been just awesome with her availability and trying to make things work. And we've had just I can't even explain how thankful I am and how cool it is, the kind of participation that we've received from the pro bono mediators that are doing this, again, free of charge.
And if I may jump in, the whole mediation plan was scheduled and organized that at most it would maybe delay the eviction process by 5 to 7 days. So from a landlord's perspective, it's not that you're going to have delays for weeks. We're talking about days. So all of this it requires a lot of coordination and a lot of outside help. But that was the idea behind it also. It would be a quick, easy, effective communication between two parties who may not have spoken about the matters at all.
Yes, thank you. So, and again, as last thing, my kind of parting shot here is that obviously our goal is to try to do everything we can to try to help the parties reach an agreement. And thus far, we've been pretty successful with the mediation sessions that we have held. So the last slide that I have provides a link to the registration form. There is this QR code for those who are technologically inclined and know how to work the QR scanner. That pops up the form. And again, this, as I say, for anybody that reviews this form, you'll end up noting it requires both the landlord and the tenant to register for participation. So that is all that I have. I thank you all very much who are here for bearing with us. I am trying to pull up the chat. I think it was Sandy or someone was trying, but for whatever reason.
I don't think there are any questions. Do you see any, Ashley?
No, I have not had any come in on my end either.
And somehow or another, I'm going to congratulate myself because, and Jordan maybe as well, but thanks for keeping me on track. So I'm Jordan and Sandy, because normally we're running it like right on an hour that we were planning on, and that is not usually my style. I usually get going way too long. So I'm going to congratulate us, Jordan, on actually keeping it.
Well, thank you very much.
Yes. And I want to thank both of you for an excellent program, for volunteering your time for this wonderful effort to help those in the community. We hope we can help more landlords and tenants talk to each other and try to resolve their conflict. And we thank the library system for helping us get the word out on this.